Former Minneapolis police officer Derek Chauvin was found guilty on multiple counts, including second-degree murder in the death of George Floyd. Now, you're probably wondering, why has it been so difficult to convict other police officers even when evidence like video footage exists? If you've asked yourself this question before, you're not the only one. Texas resident David Cawley was completely shocked after a judge dismissed his lawsuit against the officer who shot him, ultimately leaving him paralyzed.
I feel cheated, man. I feel like I've been lied to, like everything, the faith of my government and everything, it all come back to a lie.
While government agencies don't collect or report this data on a national level, criminology professor Philip Stinson of Bowling Green State University built a database of nearly 12,000 criminal arrest cases involving almost 10,000 police officers from the years 2005 to 2015. Last year, Stinson told news website 538 that only 110 law enforcement officers had been charged with either murder or manslaughter in an on-duty shooting. Only 27 of those officers were ultimately convicted. For context, the Washington Post estimates that just over 1,000 people were shot and killed by police in 2020 alone. Now, public outrage against police violence has only grown since 2015, but this outcry has not necessarily led to more police officers facing charges. So, why is this the case? Well, there are several reasons. According to Human Rights Watch, prosecutors might not want to pursue cases against officers because they have to work closely with police departments on other criminal cases. And when these cases do go to trial, some legal experts say juror bias leads to many police trials ending in acquittal or hung juries. For example, if a police officer who shot someone on camera says they feared for their life, experts say juries will tend to believe that testimony without evidence disproving it. Keep in mind, when police officers face civil suits for their conduct, city governments sometimes choose to settle with victims and their families. These settlement payouts cost some cities millions of dollars each year, but they rarely put financial stress on police departments themselves. In fact, even officers who are frequently sued have been able to stay on the force and avoid internal discipline. But the biggest reason that it's so difficult to convict police officers of wrongdoing could be something called qualified immunity. It's a legal doctrine that protects officers from being sued if their actions do not violate, quote, clearly established law. Remember David Cawley? To dismiss his case, a judge ruled that the officer who shot him was entitled to qualified immunity.
Yeah, the dude that shot me, you're not a hero, man. You're not a hero, and they covered for you. They covered your tracks, they covered up for you. In the courtroom, they snuck in a qualified immunity, still covering for you.
Qualified immunity has also shielded police officers who've done things like assault and arrest a man for standing in front of his house, seize a man's tablet after he recorded police beating a suspect, and even shoot a 10-year-old while trying to shoot a pet dog. This is simply because these actions had not previously been deemed unconstitutional in another case, and not made a part of clearly established law. People can bring civil suits against police officers for violating their Fourth Amendment rights. That is, the right to be secure against things like unreasonable searches and seizures. The Fourth Amendment is the basis for laws requiring warrants and protections against arbitrary arrests. But due to a 2009 Supreme Court ruling in the case of Pearson versus Callahan, judges who are considering cases against police officers do not have to answer whether or not the officer had violated the Fourth Amendment. Instead, they can decide whether or not an officer violated a clearly established law. A team of Reuters reporters found that this decision increased the rate at which qualified immunity has been granted. From 2005 to 2007, appeals courts favored police officers in 44% of excessive force cases in which a qualified immunity defense was raised. A decade later, from 2017 to 2019, that rate had increased to 57%. When a judge declines to establish whether or not an officer used excessive force in violation of the Fourth Amendment, they avoid setting a precedent for future cases, even when that case includes egregious acts of police misconduct. The absence of precedents, in turn, makes it difficult to convict officers in the future, creating a vicious cycle. So, absent the Supreme Court reversing the rulings on qualified immunity, what can be done to reform the system? Well, New York City just passed a bill that could serve as a model for the rest of the country. The bill establishes a new civil right at the local level protecting New Yorkers against unreasonable search and the use of excessive force, essentially making it possible for people to sue police departments under explicit local law, rather than state or federal law. Illinois and Texas are currently looking at similar bills. But police reform advocates say New York's bill does not do enough to solve the problem of systemic police violence. And some experts assert that for reforms to be truly lasting, they should focus not only on prosecuting individual officers, but also on changing the procedures that lead to excessive force in the first place.